Good morning, AP Gov. We are now officially done with everything, but I wanted to take a few minutes and review our last unit, Civil Rights and Civil Liberties. We will also now, beginning this week, just start prepping for the AP exam, which remember is May 11th at 3 p.m., and you have to have computer access for an hour if you're planning on doing that test. Um, so, real quickly, a review about civil rights and civil liberties. A civil right is a right of every person to equal protection under the law and equal access to society's opportunities and public facilities. So, you have a civil right to vote, and then you have civil rights not to be discriminated against. Um, so those are protections that you have. Civil liberties are rights that the government may not infringe on. Civil liberties are what are protected by the Bill of Rights. So your Bill of Rights lists all sorts of rights that you have that the government cannot infringe on or take away. And some of those rights that we discussed were First Amendment rights. And for the First Amendment, we went over three basic facets. The first one was that well, first of all, Bill of Rights and subsequent amendments have been secured for all Americans. States must also adhere to the rights. It was thought initially that only the federal government had to follow the rights of the Bill of Rights, but through individual cases that applied individual amendments to the states, and that is called selective incorporation. Selective incorporation forced states to also abide by the rights protected in the Bill of Rights. The first thing that we went over, or actually the second thing that we went over with the Bill of Rights, is speech. Schenck versus the United States talked about whether or not the government could ban speech during wartime um, if it thought it to be detrimental to the war effort. And government can limit speech if it creates a clear and present danger. And so you've got to just connect the clear and present danger standard to Schenck and know that it deals with wartime speech versus peacetime speech. We also talked about flag burning with Texas v. Johnson, and that is in a protected form of speech, and it's called symbolic speech. It's symbolic in that there's no actual verbal or written speech, but it does convey a message. The burning of the flag does, and so it is protected. And then we also talked about speech in school with Tinker versus Des Moines, and basically students do have a right to make political statements if it does not substantially interfere with the educational process. And in this case, wearing the armband did not interfere with the educational process and was ruled okay, and basically was ruled political speech that should be protected. And then we went over a bunch of cases where it was not protected later on after that. We also took a look at religious protections, and with the religion protections, we went through two different facets. One of the facets is the Establishment Clause, which deals with whether or not government can do certain religious activities. Engel v. Vital is the case that you need to know with the Establishment Clause, and it outlaws school prayer. Schools may not mandate school prayer. They may not write school prayers for kids to recite, and they may not force students to recite prayers. Students have a private right to pray and can do that anytime they want, but the federal government and schools cannot mandate that it happen. Wisconsin v. Yoder talked about whether or not we have free exercise rights. And in this case, the Amish family did not want to send their 16-year-old to school anymore, as mandated by the state of Wisconsin. And in this case, the free exercise rights outweighed the state right to compel education. So this was one of the first cases where the free exercise rights were given the victory over the state right. Uh, we never talked about vouchers, but can private schools get money from the public government? They can. And we also talked about how students are permitted to pray and discuss religions at clubs. We also took a look at the cheerleaders and their rights, and we also took a look at Christian Science and whether or not their rights, as far as medical procedures goes, are protected or should be protected as well. Then we got into the Fourth Amendment, which dealt with search and seizures. The Fourth Amendment talked about how the police must obtain a warrant and that they get that warrant by proving probable cause to a judge. Mapp versus Ohio is the big case for the Fourth Amendment that says that if you find evidence illegally, then you may not use it in court cases. And that is known as the exclusionary rule. And so this is the big case as far as outside of school. Inside of school, we talked about New Jersey versus TLO, about the girl who was caught smoking and then had her purse searched. And when they found her purse or went through her purse, they not only found the cigarettes, but they found marijuana, money, and all sorts of other paraphernalia. And in that case, it was ruled that school administrators can conduct searches without warrants as long as the search is reasonable, because they are just like your parents. Then we got in, and then that led to just a real quick review about national security. One of the cases that we did not get to do this year was Karamatsu versus the United States, which was about interning Japanese Americans during World War II. But basically, the Supreme Court ruled that the government may do that if it feels like it needs to protect the nation during a time of war. The Patriot Act, which was signed after 9/11, gave the government more power to review what you do, easier to tap your phones, easier to do searches via computers on you. It just gave the government a lot more power to fight terrorism and basically spy on Americans. Should suspected terrorists be tried in criminal courts, or should they be tried in military courts as a prisoner of war? That is something that is constantly being debated in the United States. Should detainees at Guantanamo Bay be given a fair trial via the criminal courts, or should they still be able to be only tried in military courts? Intense interrogation, torture. Can you waterboard a criminal or a terrorist in order to find out information? The United States has always been against torture. This is something, again, that we didn't get into, but is right around those same questions. Then we got into crime and punishment, and the Fifth Amendment protects 5 different things. It includes a grand jury clause, which says that before we go to trial, a grand jury must say that there's enough evidence to actually have the trial. Double jeopardy clause protects you from being tried for the same crime twice. So if you are found innocent, the government can't come back and say, oh, we found some new stuff, we want to retry you. They only get one shot at it. Self-incrimination deals with whether or not you have to testify against yourself. That comes through with Miranda versus Arizona. Miranda versus Arizona, the police questioned Miranda but did not tell him of his right to have an attorney. And later it was they ruled that suspects must be informed of their rights to remain silent, and that protects your self-incrimination clause. And then finally, you have your due process clause, which means that you have to go through the process of convicting a criminal properly and correctly. We also know that the Fifth Amendment deals with eminent domain, which is where the government is allowed to take private property for public use. In the St. Louis area, when they expanded 141 from 2 lanes to now 6 lanes, they had to take people's houses in order to widen the street, and they did that. And they also had to take out literally 3 to 4 subdivisions in order to do an airport expansion where they added a new runway. And so all of that was done through eminent domain. And then finally, with the Sixth Amendment, we talked about how you are also given some rights to a speedy and public trial, and you also have a right to an impartial jury, meaning that they have not made up their mind whether or not you are innocent or guilty. You are also have a right to counsel. You have a right to a lawyer, and that comes about through Gideon versus Wainwright, that you have a right to a lawyer for all cases, not just death penalty cases. And you have a right to confront your accuser. You have a right to know who's accusing you, and you and your lawyer have a right to cross-examine the other side. And so those are the elements that make up the the Sixth Amendment. The Eighth Amendment we did not get into this year, but we have talked a little bit about uh, the death penalty and whether or not the Eighth Amendment prohibits the death penalty. More and more states are banning it, more and more countries are banning it, and it could be conceivable that in our lifetimes the United States will ban the death penalty as well. Um, and so that was what we would have been discussing at this point as well. So that's a little bit of a review of the Bill of Rights and the differences between a civil right and a civil liberty. Just make sure you iron out the differences. We have a couple of mandatory cases that you'll need to know from this. And then we will basically, for the rest of this week, be prepping for our AP exam. We will also, toward the end of this week, take the Missouri and U.S. Constitution test. Super simple. Do not freak out in any way, shape, or form. It's just a real easy way to review things. So hope you enjoyed, and I will talk to you later.